Good evening. This is from my last video, the quarantine 5/24/20. No, we're not going to talk about quarantines. We are going to talk about people who have a problem with the truth. In other words, they disassociate themselves from it as often and as hard as they can. So this is, of course, Two Truth for Liberty, my favorite sovereign citizen, who is a lying liar who lies. And this is what he posted about 8 hours ago on that video from the 24th. He says, "While I previously said that executive orders cannot preempt state law, I clearly meant that in the context of executive orders without congressional authorization." Well, let's test that out, shall we? In my Dummies Guide, where is this at? Dummies Guide to Authoritative Sources on the 18th, he responded as such. Now, remember, I said that executive orders preempt state laws. They're below statutes passed by Congress, but they do supersede state law. They supersede state constitutions, state legislation, state rules and regulations. They supersede the whole kit and caboodle. Well, he says no, or not exactly. Such orders dictate what federal executive branch officials and employees are required and expected to do. They also do that, but that's not the only thing that they do. If what they order to do is something which violates state law, there's no preemption without the state choosing to allow a preemption. Can you cite authority for federal executive orders preempting state law? And absolutely, it's very easy for me to do. Armstrong versus United States. This is Armstrong versus United States. I'm just going to be in the syllabus. You can read it. The language is in the case. The syllabi are correct. But just to get through this quick, I'm just going to go through the syllabi. The proclamation referred to as a public act of which all courts of the United States are bound to take notice and to which all courts are bound to give effect. It is referring to the President's proclamation. The proclamation referred to is a public act. It is a law which all courts of the United States are bound to take notice and to which all courts are bound to give effect. What it is saying here is, under Article 6 of the U.S. Constitution, the U.S. Constitution and the laws of the United States, public acts, shall be made in pursuance thereof, which shall be made in pursuance thereof. So it's referring to just laws that are constitutional. And all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of the state to the contrary notwithstanding. So the Constitution and the laws of the United States made in pursuance thereof are the laws of the land. So if an executive order is either grounded in the Article 2 of the Constitution, which grants the President authority and power over certain things, or if it is implicitly or explicitly granted to the President via an act of Congress, and if it is something that Congress can actually regulate, because Congress is limited by Article 1 limitations on what they can regulate, then the President can make an executive order using either that implicit or explicit grant of Congress or his Article 2 powers to supersede, preempt, override state law. Pretty simple, pretty easy, done and done, right? Makes sense? And then I laughed at there is no preemption without the state choosing to allow a preemption because, again, Article 6 says, no, that is just wrong. And so he says, wrong, title of the video is now oxymoronic, blah, blah, blah. You proffer Armstrong versus United States as authority. This authority for federal executive orders to preempt state law failed. Did you not even read or analyze the case? And that if you did, please identify the state law that was preempted. Again, I didn't have to identify the state law that was preempted. All I had to do was show that a federal executive order a presidential executive order is federal law, in which case Article 6 kicks in, and bada boom, bada bing, done and done right. And then he says the Abandoned and Captured Property Act is federal law and not an executive order, which just made my mind explode. Because it's talking about the President's proclamation. The proclamation referred to as a public act. The President's proclamation granting unconditionally and without reservation. So I linked in these. By the President of the United States of America, a proclamation, blah, 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 continues on page 2. Down here, in here, it says, unconditionally and without reservation, to all and every person who directly or indirectly participated in the late rebellion. To all and every person who directly or indirectly participated. This is from a presidential proclamation, which is what they used to call executive orders. He literally doesn't know what he's arguing about. But I'm the dummy. Conclusion, you have no authority for your claim of preempting state law. Again, you don't understand. I'm going to just skip down through this. Eric the Fatid, who also doesn't understand, says, thanks for handing Merbface a smackdown. He's grown tired of doing it himself. Because, you know, Eric the Fatid always gives me those brilliant smackdowns. So I give him the links, and I said, but you missed the point. The executive order is federal law, and what does Article 6 of the Constitution say about federal law? I mean, I don't know how much clearer I can make it. So then he spins around, and he wasn't asking for me to assign an authority for federal executive orders preempting state law. He was now looking for examples of it. So I give him an example. This is an executive order. This is 13132 of August 4th, 1999, which is literally an executive order that is directing regulatory agencies on when, why, where, and how to preempt state law. I mean, this is kindergarten grade stuff. Well, maybe not kindergarten, but at least in your civics class. Good Lord Almighty. And then he says, my only provides support. There is no federal law created by an executive order. Okay. And then he says, Government 101, the legislative branch of the federal government creates federal law. See Constitution, not the executive branch. Now, just remember what he was arguing previously about executive orders. He clearly meant that in the Constitution of executive orders without congressional authorization. When he said they can't preempt state law, he clearly meant, I mean, aren't you seeing how he clearly meant that they couldn't do it without congressional authorization? Which he's even wrong there, because, again, the power can come from Article 2 of the Constitution. This isn't freaking hard. And then tell him to argue with the Supreme Court, and then he says that the Supreme Court didn't say what the Supreme Court said, I guess, in Armstrong, and that it's not real law or something, but whatever. Anyway, I think I'm making my point. So then we skip ahead. This is, I made the video on it because I'm like, hey, you know what? I'll just throw it out there. If Too Dumb for Truth has questions regarding executive orders and state law preemption, I'll just throw it out there. And I explain it. And executive orders are policy guidance. Policy is not law. I mean, oh my God. He fails on thinking an executive order is law. That is my primary error. It is true, he says, the Constitution says that all laws, and he quotes laws, made pursuant to the Constitution shall be supreme law. But according to the Constitution, law is created by the legislative branch. Okay, well, argue, like I said, argue with Armstrong, because Armstrong said that the executive order referred to is a public act of which all courts of the United States are bound to take notice and to which all courts are bound to give effect. It is a federal law. So I let that one just lie there. So then on this one, this is Quarantine Part 3, the finale from May 24th of 2020. And I'm aware that Teresa made a video and then had a panel where allegedly she discussed this. No one will provide me with a link, a timestamp to where she actually successfully rebuts my argument. So if you find it, go ahead and link it to me. Anyway, he says the reasonable person who claimed that executive orders preempt state law would willingly admit that was wrong rather than proffer one case from long ago that doesn't even pertain to preemption of state law. My God, this guy is thick. But remember, kids, what he was actually trying to say when he was saying that executive orders can't preempt state law, he clearly meant that in the context of executive orders without congressional authorization. So then I give him a case. This is Letter Carriers v. Austin. In this case, there is an executive order. Again, I'm just going to go through the syllabus. there is an executive order that that govern labor relations and federal employment. The basic provisions of the executive order are like those of the National Labor Relations Act and similarly afford wide latitude for union freedom of speech. Now, they afford wide latitude for union freedom of speech. The fun thing about freedom of speech is, while people often confuse it with the First Amendment, it is not the First Amendment. Freedom of speech, First Amendment is the floor for the government's intrusion into your freedom of speech. That's the floor. States can raise the bar, and states can give you more protection, more freedom of speech. The First Amendment is the floor for freedom of speech, from regulation, censorship, etc. by the government. So what it says here is the relevant law here is Executive Order number 11491, governing labor relations in federal employment. The basic provisions of the executive order are like those of the National Labor Relations Act and similarly afford a wide latitude for union freedom of speech. The partial preemption of Lynn was this case here in which they held that that the NLRA and the NLRB partially preempted state law in it preempted state common law in defamation cases, and you had to prove actual malice. So the partial preemption of Lynn is thus equally applicable here. The free speech protections affording union organizing efforts to expand post-recognition organizing activity to the same degree as pre-recognition activity. But it's saying that federal labor laws prohibit uninhibited, robust, and wide open debate in labor disputes, and the relevant law here, the relevant federal labor law here, is Executive Order number 11491. It directly superseded, well, partially superseded a state law. And it only partially superseded it because Congress didn't intend to occupy the field. So now that we have that out of the way, I give him the link, and I said, this is why I don't try to convince sovcit. And he said, you apparently love word searches, but fail to analyze the case that contains the words you're looking for. Oh my God. That case, nor Lynn, so I guess neither that case nor Lynn, held that executive orders preempt state law. Rather, the executive order was to be construed such that, wait for it, First Amendment protection applied, and thus the federal law of the First Amendment, not executive order, would preempt the state law concerning defamation, or libel. Oh my God, it just hurt so bad. Anyway, I said guaranteed under federal law. Both cases are analyzing federal law, which extends freedom of speech below the floor of the First Amendment. Lynn, blah, blah, blah. I said read the syllabus. It literally spells it out for you. And et cetera, et cetera, et cetera. But anyway, my point is that he is a lying liar that lies. And he is still wrong even now. Because once again, a presidential executive order can derive its power from two sources. Not one, not just congressional authorization, but from two sources. Implicit or explicit grants of power by Congress, as long as that grant of power comes from a basis that Congress has authority over. Or it can come from Article 2 powers of the president. Anyway, I beat this one to death. Thanks for watching. Have a great evening.